Thank you so much for joining us for Spirit, the stimulating program initiative for retirees that inspires thought. I'm Judy Steinig, Director of Programs, Director of Community Programs for the Orthodox Union, and it's my honor to coordinate and host this program. The OU created Spirit several years ago as an on-site program, and now we are happy to present it as a virtual program for baby boomers, retirees, not yet retirees, empty nesters, sandwich generation parents and seniors, everyone who is looking for opportunities for spiritual, physical, educational, and intellectual growth. Since we are all still sheltering in because of the pandemic, Spirit is the perfect way to engage everyone in a virtual setting. This week in Spirit, we will be exploring various legal matters that are relevant to our demographic in both secular and halachic matters. Our current situation with COVID shows us the importance in dealing promptly and properly on all of these issues. Today's topic is Mishigas, avoid the craziness of not being legally prepared. And our presenter is Debby Rosenfeld, Esquire, who has been with Ronald Fatula and Associates for 15 years. She practices in the areas of elder law, estate planning, and real estate. And you can find her very comprehensive bio on the OU community website under this program. We are very happy to welcome Debby to the Spirit Forum and appreciate her taking time out of her very, very busy schedule to speak with us today on these very important legal matters that each one of us must address as soon as possible. It's my pleasure to turn the podium over to Debby.
Hi, everyone. I, first of all, want to thank you so much for joining. And this is as close as we're going to get, but I do see all your faces and your names, and I'm very appreciative for your attention and taking out the time. So I'm an elder law and estate planning attorney. And as such, I specialize in issues that affect the aging population. And we try to help people in so many ways. We help people preserve their assets and income while they're alive. And we also help people implement plans as to how to distribute their assets, how their assets should be distributed once they pass away. So while I am familiar with dealing with people in an emergency situation, I have clients who call and say a parent has fallen ill suddenly, or a niece or nephew calling about an aunt and uncle who has no kids and has had a stroke. I deal with emergencies. My typical day is usually somebody making an appointment in advance, coming to meet with me. We sit together in a room. It's pretty informal, as you can see. I'm not terribly intimidating. We talk about very, very personal things. You know, you talk about your children, again, family members, relatives. You talk about money. These are very, very personal, but it is an informal setting, and people talk to me about their aspirations, what their options are, what their goals are, and I, in turn, give them a whole slew of options, and we develop a plan. So that used to be how I worked, and this all changed with COVID-19. All of a sudden, I found myself working from home. I found myself trying to help people whose loved ones were desperately ill, and who had not done the planning that I often exhort my clients to do. Yes, I've been practicing for over 25 years, and I have run to hospitals, I've run to nursing homes to help people in crisis. I've done bedside wills, I've signed and witnessed powers of attorney, healthcare proxies. But what exacerbated this particular situation was that I could not get near a client. I mean, people were in hospitals, they couldn't even see family members, let alone an attorney coming in with a briefcase and pulling out all these documents. So it was an extremely, and it still has been an extremely challenging time. But what COVID-19 did for me, amongst many other things, it did show me, it illustrated for me how important it is. You know, it really drove home the point that get your documents in order. Don't wait for a situation like this where there's an emergency. Do these things in advance when you have the wherewithal, when you have the time, and when you are of sound mind, and when you don't have all the stress that we've all experienced in the past several months. So what I'd like to do today is focus on some of the documents that you need, if not all of the documents that you need. And again, I recognize that this is a national program. The documents that I'm going to discuss today are relevant in every single state, you should know. And also, if anybody is calling from Israel or another country, these are documents that you need wherever you live, wherever you may be. They might have different names, but they all serve the same purpose, okay? So my initial description is going to be a bit basic, but as I go through this talk, towards the end, I will talk a little about advanced planning and how we actually go about preserving some of our assets in the light of long-term care needs that people might experience. So first of all, again, I'm sorry for those of you who are very familiar with this, but I'm going to tell you that the most important document, and you'll see why, but I think that the most important document that every person needs to have is something called a power of attorney. Now, again, it might be referred to by different names in other states, but I think it's pretty universal that it is a power of attorney. Interestingly, it has nothing to do with an attorney. I don't know why it's called power of attorney, but essentially it's a document where you are authorizing somebody else to act on your behalf with respect to financial matters. Now, again, I'm not going to keep on mentioning COVID-19, but I cannot tell you how critical this document was for people who were suffering during this experience. Not only that, even if you were lucky and fortunate not to get sick, a lot of people were away. I have clients who are snowbirds, who were in Florida. They needed to have these documents just to have their children or loved ones act on their behalf with respect to things that they could not address simply because they were at home, away from home in a different place. So the power of attorney is a very important document. What it does is it basically says, I, Debbie Rosenfeld, I designate, and I can name my husband, I can name my child, I can name both of them. I'm designating an agent to step in and act on my behalf with respect to my financial matters. Again, the thrust of the document, the plan is that it only comes into play if I become incapacitated. However, if you look at the actual document, and people have said this to me, they say, I don't understand. It looks like it comes into play immediately, meaning, yes, I've signed a power of attorney. It has my signatures notarized, and immediately the next day, my agent could technically take that form and go to the bank and start acting on my behalf. Why is this like? Why do we have this? There used to be something called a springing power of attorney, which meant this only goes into effect in the future when I am deemed incapacitated. So I can tell you that my experience has been the main purpose of this form is for somebody to step in and continue your financial life in a very fluid, expedient way. And if that person, whether it's my child, my spouse, my cousin, whoever it is, if they first have to run to doctors to label me as disabled or incapacitated, that could be a real obstacle. First of all, with HIPAA rules today. Second of all, many people, many of my clients don't go to doctors on a regular basis. So that this springing power of attorney causes a lot of problems. Do I recommend it? So I don't recommend it in light of what I've just said, but I would recommend it for a person who doesn't necessarily have anybody who they trust fully. So I'd say, okay, at least have that document in lieu of having anything. But my point is the typical power of attorney does go into effect immediately. What do I tell my clients to do? I say, put it in not a safe deposit box. Put it in a fireproof file in your home. Let your children or whoever the agent is, let them know where the document is located so that they will know how to retrieve it and get it in an emergency. And the reason why I don't say a safe deposit box is because those are hard to access. You'd probably need a power of attorney to access somebody else's safe deposit box. Well, it's not going to help you if that power of attorney is locked away and sealed in a safe deposit box. So that's not something that I recommend typically for where to keep your documents. I would say fill out these forms. You have peace of mind that you've done it. You put it in a place that's accessible, but it's still under your control. So it's not utilized until a future point. Now, I could talk about powers of attorney that in themselves for an hour and a half. I'm going to say a few more things that I think are important. Most of you, and I know that you're familiar with computers and familiar with obtaining these because you're on this webinar. You could Google power of attorney and you will see you could print it out. You could spend $25, $50 and print one out and not really feel that you need a lawyer or somebody to intervene with respect to this process. So as I mentioned before, I've been doing this for 25 years, and I don't think I'm misrepresenting things when I say I have never in my entire career seen a power of attorney that was prepared by the person themselves, meaning a person who goes and just prints it off the computer and gets themselves a notary. I have never seen it suffice. And that's for two reasons. The first reason is that there are specific rules as to how these documents have to be executed. Now, again, because I practice in New York, I'm going to give New York as an example, but this is true of every state. Every state has its own rules and idiosyncrasies, but in New York, there are various places on the form where I have to put my initial. So if I were filling out this form, I would put DR by, let's just say the letter P, by this letter, and then I sign. If I, instead of putting my initials, I check it off, right? Instead of putting DR by the letter P, I just put a check. Guess what? Any bank or financial institution has the legal right not to recognize that form. So for that reason alone, it just makes sense to go the extra yard and consult with an attorney. Yes, you might end up spending more money, but I promise you, look, my wish to everybody on this webinar is that nobody will ever need to use your power of attorney because you're going to be of sound mind and have capacity for the rest of your lives. But unfortunately, that's not reality. So it makes sense to have a form that is comprehensive. That's the other thing. Like you might say to me, well, if I can get the form off of the internet and then I just make sure that I sign it properly, what's the problem with that? And I will tell you, as a practicing attorney, I've done this for many years, there are additional powers that I add to the form, and I'm hopefully going to touch upon them later in this discussion. One of the most important things that I look for when I see a general power of attorney, does the agent, that's the person, I appoint somebody, the agent is the person who's allowed to act on my behalf, does the agent have the power to make gifts, to make transfers, to create trusts on my behalf? A trust is a very important document that's needed with respect to estate and elder law planning. So there are a lot of powers that we add to this form that are not inherent in the basic form you're going to get off of the internet. Okay, so, and also, by the way, every state has different requirements. So for example, Florida requires 2 witnesses. So if you have a power of attorney that you executed in New York, no witnesses, that's not going to really help you for a Florida transaction. My advice to people who have property in more than one state is to probably have a power of attorney for each specific state where you own property so that you don't run into any problems. Okay, so that's power of attorney. Again, I could talk for hours, but I want to give you an overview. Next document, and I know that Rabbi Zone, God willing, is going to be talking about these documents in detail, so I'm only going to discuss them peripherally. The next document is a healthcare proxy. Again, it might be referred to as a medical power of attorney. It depends on the state you live in, but in New York, it does say healthcare proxy. Typically, there is going to be some reference to health or medical in the document so that you would know what it's referring to. Healthcare proxy is the medical counterpart to a power of attorney. If I, Debbie Rosenfeld, am incapacitated and I can't make decisions for myself, medical decisions, I appoint Mayor Rosenfeld. So the difference between a power of attorney and a healthcare proxy, first of all, power of attorney is financial, obviously, and you can appoint more than one person to act on your behalf. With a healthcare proxy, you can only appoint one person at a time. And I think the reason makes sense. Doctors facing an emergency decision don't want 2 agents or 3 agents fighting amongst one another. So you appoint one person at a time. Obviously, you can appoint successors. So if that person is no longer available, for whatever reason, the second person can step in. And this form is just so important. But if you noticed, I said at the beginning, about 5 minutes ago, I mentioned the power of attorney is the most important document. It's not that I think finances are more important than a person's medical condition. Many states have laws that even if you don't have a document in place, the person's next of kin or the person's spouse. New York, for example, has the Family Healthcare Decisions Act. Even if I don't have a healthcare proxy, my spouse can act on my behalf. And if there is no spouse, it's the children in order of age, so that there are ways to get involved with the person's medical decisions without necessarily having a document in place. But obviously, the healthcare proxy is extremely important because then you get to choose your agent. I have a woman, a client, happily married, a widow. She has a wonderful family. She has 4 kids, but they, for whatever reason, religiously are more to the left. And she feels very strongly that she wants somebody, her agent, to adhere to halacha and to all the Jewish laws. So she did not name them as her agent. She named a dear friend of hers who she feels is more in line, aligned to her views and her wishes. So that's the healthcare proxy. Again, one agent at a time. The final document, and again, Rabbi Zona is going to focus on this as well, it's called a living will. Healthcare proxy, again, the sole purpose is to appoint somebody to make decisions, but the living will discusses what those wishes are. And a typical living will say, if I'm at the end of my life and there's no hope of recovery, I don't want extraordinary measures taken. What do I do for my frum clients? The living will, by the way, is something, it's almost like a roadmap for the person who is appointed as on the healthcare proxy. For my frum clients, I also do something called a halachic living will. That doesn't mean that the document articulates the end of life halacha. It basically allows me to designate a rabbi who will help my family member make that decision, right? So the halachic living will, I tell my clients, have your healthcare proxy. That's what they're going to ask for if you're ever hospitalized. But if an issue arises and there's concern or question as to how you should be treated medically from a halachic point of view, you can whip out your family member can whip out the halachic living will, and it can say, for example, my mom wanted us to consult with Rabbi Zone as to the decisions we're going to make with respect to her end of life. So just to summarize, the power of attorney that I mentioned, the healthcare proxy, which relates solely to one's medical decisions if they become incapacitated, the living will, and the halachic living will. These are 4 documents that I believe every person needs to ensure that their affairs are in order. The beauty of the healthcare proxy and the living will, copies are just as effective as the original. So God forbid you're facing a medical emergency, you don't have to make sure that you have a Xerox machine around. You have a copy of it, you're fine. Your family members have copies of it, that's okay. What are these all called? All these documents together, combined, are called advanced directives. And I know that if I have those documents I just mentioned, I pretty much can be assured that if God forbid I become incapacitated, I'm having medical issues, that I can actually know that my affairs will be handled because I've appointed people I trust and love to take care of me. They're called advance directives. The most important thing, or not the most, but something to realize is that they are null and void when you die. Now, this might seem basic to anyone listening to this, but I can't tell you how many people come into my office and they say, Mom passed away, but I'm her power of attorney. No, power of attorney does not allow you to access anybody's bank account once they pass away. Obviously, a medical healthcare proxy terminates when the person dies, but power of attorney, again, null and void once the person dies. So if you have these documents while you're alive, you know your affairs can be managed. But then this segues into part two. What else do people need in order to make sure that their entire plan, not just while they're alive, but also after their demise, what else do people need to ensure that their affairs are in order? And so probably many of you are familiar with what document do we need to dictate that what happens to our assets after we die. That's a last will and testament. And that's basically the document where I say, after my death, I leave my house to so-and-so, I leave everything else to my children in equal shares, whatever it is that I want, whichever way I want my property distributed, that would be covered by my last will and testament. So before I go any further, I do want to mention COVID-19 again. I mentioned that all of us, and as Judy also mentioned, most of us are still practicing isolation. We are slowly re-entering the world right now, depending on where you live. Some people are entering phase 1, some people are entering phase 2. So how are we effectuating some of this planning while we are stuck at home? And the answer is that thankfully, many governors, including Governor Cuomo, many governors have passed, I guess, edicts. They're basically, I guess, they're temporary law that's as a result of a special or unusual situation. We have been supervising wills from the home. And so as long as a person can access a computer, iPhone, Zoom, anything that I'm able to visually see them, I've been conducting virtual signings since this happened. It took about a week for everything to go into place, but there are executive orders out there now that are allowing signings where nobody has to come together, and we've managed to do this. And so it's called a remote notarization. I've had members of my office staff also present via Zoom, so that everybody's witnessing somebody sign their document from their own home. And even though we are now re-entering, the economy is opening, and God willing, we should all be safe, they have extended these orders because there are so many people who are uncomfortable about coming out. And we also, unfortunately, don't know about a second wave that might take place. So these orders have been extended, and should all know, I don't want any of you to think that if you don't have these documents, you have to wait till you can meet face to face with an attorney. You can do this from the comfort of your home, provided, and I've even had very elderly people who are not that savvy. I've had them do this with their aides. So if somebody has their aide, I've done it on their aide's iPhone or Zoom. So, and it's worked. The other thing that I've been doing is I've been witnessing a lot or overseeing the signing of documents outside. So that's another way that we're really trying to accommodate anybody who wants to engage in this kind of planning. Now, again, I'm putting it out there just so you all know, you don't have to necessarily wait until everything is in order, because that might be a long time. I think we're not really going to be safe until a vaccine is in place, and that's, unfortunately, that's not happening tomorrow. So just moving on, as I said, a last will and testament is going to cover the way your assets are distributed when you die. So now let's talk about that for a second. That's a will, and I think most of you are familiar with what a will accomplishes. What I think you might not realize, and what is when a will is involved, when a will is relevant and when it isn't. Again, the example I give, I like to give this example because I think it helps clarify things. I have a client who comes to me. They have $8 million, okay? That's a lot of money, and it's a wonderful size estate. It gives them comfort. And in that situation, I'm going to tell them, you know what? You need, not only do you need an estate plan, meaning a will to tell you how everything should be distributed, we also need to minimize estate taxes, because there might be, federal law right now allows every person to pass $11,580,000. That's a lot of money, but that's due to sunset in the year 2025. So somebody with $8 million really does have to do tax planning. And so, they tell me all about this account, and let's just say it's held with Merrill Lynch. Their $8 million is completely centralized in one account that's being managed by Merrill Lynch and has a lot of different facets to it, but it's all under all these sub-accounts under one main account. And I go ahead and I do this very, very fancy will, and I have all the language in there and all the planning that I could do to help minimize estate taxes and to allow everything to happen fluidly. What the person fails to tell me or doesn't remember, they have named their 4 children as beneficiaries on this account. So again, we have Merrill Lynch. It names 4 children as beneficiaries, and person passes away. I take out my big fat will that's been sealed, and they ask me to hold on to it, and I'm all ready for like a serious probate where I can implement my tax planning. And the family member calls me up and says, what do we do next? And they let me know, we contact Merrill Lynch just to say we're going to be probating the will. And Merrill Lynch tells us, sorry, there are 4 named beneficiaries here. My point is that in a situation like that, those named beneficiaries on that account overrides the will. It doesn't matter what the will says. It doesn't matter how complicated the will is, how much the person paid for the will. In that situation, if that's all they own and they have named beneficiaries, the will is irrelevant. Okay, what other examples? If you have an account and you have a joint name on it, so it's mom together with oldest son is a joint owner on that account. By operation of law, when mom passes, that account passes to the son. Even if I had a will, even if mom had a will that specifically said, I leave account number 1234 at Chase Bank to my niece, it doesn't matter. Oldest son will inherit that account because his name was a joint owner. So what I'm trying to get at is that a will ultimately only governs what's in a person's name alone when that person dies. And that might be okay. That might mean you don't need to go through probate. My point is that you just need to know. People often say, I want to avoid probate. I want to avoid probate. Well, I will tell you that if you do die with an asset in your name alone, then your estate will go through probate. What happens? Your will articulates how your assets will be distributed. Typically, people use an attorney, but sometimes people like to do it alone. We prepare a petition, we present it to the court, and the court we're basically informing them who this person is. The person died, we're informing the person what assets did they leave in their name. That gives the court the idea of size of the estate. We also give the court a family tree. Now, why is this important? And you'll understand why I'm telling you this. So let's just say a widow dies and she has 3 children. And she leaves her will. Her will says, I leave everything to my 3 kids. And she dies with a house in her name alone. Based on what I've told you, we will have to do probate for that estate because she had an asset in her name alone, okay? Who are her heirs? They are the people named in her will, her 3 children. okay? So if she names her 3 children, they are her heirs. Well, guess what? Surrogates court looks at that and they say, if this woman had died and she had no will, let's say she had, there are many people who die and they don't put these things in place. They don't have wills. I just had a whole discussion with you about how many of my clients who called me recently did not have these basic documents. But what does surrogates court do? They want to protect the people who would have inherited if there was no will, right? Now, in this case, if this woman is leaving everything to her 3 kids, she's a widow, she has no spouse, her 3 kids are the same people who would inherit if she had no will. If she had no will, they would be referred to as distributees, and they would inherit her estate under state law. Okay? I'm gonna tell you that probate in that case is extremely straightforward, right? The beneficiaries named on the will are the same people who would have received if there were no will. They have to get notice. So what? They're getting notice anyway, and they're inheriting anyway. And I will tell you that probate is not necessarily the nightmare that people think it is. You know, that's probably a very big misconception in my practice where people come into my office and the first thing they say is, I want to avoid probate. I want to avoid probate. And I'm letting you know, yes, you can avoid probate, and I'm going to discuss how we do that. But in most instances, probate is straightforward. It's a fairly genteel process. It's not terribly argumentative. And yes, there are some fees that are involved, but that's just part of the probate process. When does probate become problematic? I'm going to go back to my client. Again, the same widow. She has the 3 kids. Now, let's just say she says to me, one of them is rotten. He hasn't called me in 20 years. I don't even know where he is. So I'm leaving everything to my 2 kids, but I'm leaving out that 3rd child. So in that case, probate is going to be a little more problematic. As I mentioned, every person who would have received if there were no will, that person has to receive notification. So now we have a situation where probate could be complicated. Number one, this child has to be located, right? This disinherited child, because he would have served to get something if mom had no will. He has to be located. He's also given his day in court. He literally gets a roadmap that says, Mrs. Finkel passed away and her estate, her will is going to be probated in court on such and such date. And you can, and I'm not exaggerating, the child will get this notification. And you can show up at 10 a.m. on June 23rd if you feel for whatever reason that there's a problem. Now, it doesn't mean that this estranged child is going to ultimately prevail, but this estranged child can cause a lot of problems, can increase the cost of the probate, and also can cause a tremendous delay. And, you know, again, probate is a fact of life. It's kind of adding insult to injury. So if you've just lost a parent or a loved one, and then you have to deal with all of these rules and these regulations, and with a potential fight over a will, that's something that people are going to want to avoid. So again, I am going to let you know, I just want to recap. A will governs what's in a person's name alone when they die, right? That's going to typically be things like real estate. Most often, if a parent has more than one child, unless there are extenuating circumstances, they're not going to add a child to the deed. That means that will be an asset that has to go through probate. Many accounts that people have, especially IRAs, annuities, that typically has a named beneficiary, and that bypasses the need for probating that particular asset. So what do people do if they want to avoid probate? So first of all, even though I've said it's a fairly genteel process, it's extremely straightforward, there are still people who feel, when I die, I want my family to access my assets immediately, and therefore I want to do something to prevent the entire probate process. So this brings me to another document. Again, Not everybody needs this document, but it's another document that I often deal with and is very, very much part and parcel of the entire estate and elder law planning practice. And that is what we refer to as a trust. Okay, so, and I will also cover some long-term care planning in conjunction, in addition to discussing the trust in general. Trusts do a lot of things and they're all different types of trust. But if you want to understand visually, what is a trust? A trust is a separate entity, okay? It's not me, it's not you. It's a separate entity. So visualize literally like a person standing next to you. And let's just say I decide, for whatever reason, I lecture about this all the time. This is what I do for practice. Let's just say I decide, Debbie Rosenfeld, I don't want my kids to have to endure, or my husband for that matter, to endure the whole probate process. Even though I just finished telling you how straightforward it is, I don't want them to have to go through that. What do I do? Again, I can name beneficiaries on all of my accounts, right? Because that will avoid that particular asset that has a named beneficiary will not have to go through the probate process. What do I do about my house? So visualize, again, I said it's a separate entity, a different person. Visualize an envelope, or I tell my clients, visualize an envelope or a box. And I take the deed to my house, Debbie Rosenfeld, and I place it in my envelope that I've created. That envelope, again, it's a separate entity. So it's just, I like people to have a visual where you're literally taking the deed to your house, or the deed, it doesn't have to be the house you live in. It could be an investment property. It could be a vacation home. You take that deed. If it's a co-op, obviously there is no deed. That's reflected by a stock certificate. Or if it's a condo, that's reflected by a deed. Whatever the piece of property is, and it could also be an investment account. I retitle that piece of property and it goes right into my envelope, right? My envelope, remember, box, my envelope, there are different kinds of envelopes and boxes because there are different kinds of trusts. But this envelope is going to be governed by an agreement, and it's going to say, so let's just say it's myself. I, Debbie Rosenfeld, I leave my house, which is now owned by my trust because I retitled it in the name of the Debbie Rosenfeld Trust. I, Debbie Rosenfeld, leave my house to my husband, and if he predeceases me, it goes to my 4 kids. Now, when I pass away, hopefully it won't be for a long time, but when I pass away now, to access that house, if it was in my name alone, my kids and my husband do not have to go through the probate process because my house is now in a trust, which means it's no longer in my name. And remember I said, probate only applies to assets that are in the person's name alone when they die. So if I've gone through the process of putting my assets into a trust and there's nothing in my name alone when I die, probate will be avoided. So now I want to say a couple of things. Probate obviously is different in every state, okay? Just so that you know, I deal with a lot of clients who have, who are snowbirds, part of the year they spend in Florida. Years ago, and it's not that true anymore, but years ago, for whatever reason, probate in Florida was very, very time consuming and very, very costly. So for that reason, if you spoke to any, and I'm not talking about today, 2020, I'm talking about probably 15, 20 years ago, if you spoke to anybody, and this is what people would sit around by the pool or on the beach, and they would talk about their trusts. Everybody in Florida had a living trust. Again, there was reason to avoid probate because the process was costly and complicated, okay? Florida has streamlined its probate process, and a lot of it can now be computerized, and it's no longer as strenuous as it used to be. So, but I will tell people who live in more than one, people have only one domicile. There's only one place that we view as a place as being our own home. That's where so that state is where your will gets probated. So let's just say I'm traveling in Nevada and I also have a place in Florida and I have something else in Denver. At the end of the day, it doesn't matter where I die. If I view New York as my home, that's where my will be probated. I'm just throwing out there that anybody who owns real estate in more than one state, right? So if I own a house in New York, but a condo in Florida, that would be another reason for a trust, because typically you have to probate, you have to do an ancillary probate in every state where you own real property. That's another reason where I advise, please transfer your assets to a trust, your real property for sure, because ultimately your kids or your heirs, your beneficiaries will have to initiate probate in every single state where you own real property. So that's another reason. So that would be a situation, examples like that, where you either have an heir, a child that you're excluding, or you have real property in more than one state, or you don't have any close relatives. I have many clients who come to me. They're widows or widowers, or they never married, no children, no living parents, no siblings. Probate of that person's will is going to be hard because we have to find their closest relatives. So examples like that are where a trust really is a good idea. So now we're talking about trust, and I realize really all I'm doing today is I'm spotting issues. I'm letting you know that you need certain documents, that you should absolutely consult with an attorney if you feel that any of the things that I've said are relevant to you. But I do want to focus on one last topic in the context of trusts. The trust I just mentioned, where I said I transfer my house to the trust, and the trust has an agreement that says Debbie Rosenfeld leaves her home to her husband upon her death, and if he's no longer alive, to her children. There are all different kinds of trusts. The kinds of trust that I just described is what I would refer to as an envelope that is open. It's my trust. I am not giving up any control of that asset. I own it, I put it into my trust. Now my trust owns it, but guess what? I'm the trustee. So I can manage my envelope, I can manage my house, I can do everything I want. I could sell my house, I could refinance. That trust is an extension of me. Why? Because it's revocable. I'm titling it as a revocable trust, which means I can take the house, I can put the house into the trust, I can take it out. It's mine. I am not relinquishing control, and my sole purpose in doing the trust was to avoid probate. And in my example that I just gave, that trust, that revocable trust, is an open envelope. There are other types of trusts that we do, and yes, those trusts will also have the benefit of avoiding probate, but they accomplish something else as well, and that's what I refer to as asset protection. I have many clients who come to me, and I give them the same little lecture that I just gave you. I tell them what documents are important to have, and they talk to me about who they want to leave their assets to, but they have an added concern that I haven't touched upon yet, which I'm touching upon now, and that is, Debbie, you've told me all the things I need to know, but what if I need long-term care, right? What if I reach a point in my life, obviously, God forbid, where I can no longer care for myself and I need either a home health attendant or, God forbid, a nursing home? What do I do? How do I protect my assets? And trusts have a lot to do with the planning that I do. Again, every situation is different. Again, I will tell you that what I'm going to talk about now is really trusts in the context of Medicaid planning. What is Medicaid? Medicaid is basically a governmental program out there. It's federal, and it's the only program in the United States, the only governmental program that covers the cost of long-term care. Unlike other programs, any of you who have turned 65 or are disabled are familiar with Medicare. You could be a multimillionaire and get Medicare. And Medicare will cover your doctor's visits, it'll cover hospitalizations, but it doesn't cover this long-term care component. Medicaid is the only program out there, but unlike Medicare, Medicaid is only available if you are impoverished. Okay? I want to say Medicaid, I said it's a national program, but every state is required to contribute its own funds. Therefore, every state has rules that are potentially different than other states. So again, ultimately, you would really have to speak to somebody, an attorney in your state who's familiar with this, familiar with long-term care planning, familiar with elder law. But again, I will tell you across the board, there's a 5-year look-back period, right? So if, God forbid, I need nursing home care, I can't just take my assets at that point and give them to my children and say, you know, gotta go, here I am, I'm giving you everything, and try to go into a facility the next day. No, there is a 5-year look-back period that Medicaid imposes, and that's across the board, meaning every state. Now, some states also have what we call a community Medicaid, which is home care, okay? Right now, when I say 5-year look-back period, I'm talking about nursing home care. Some states have no home care program to speak of. New York happens to be a liberal, for example, Florida has no home care program. New Jersey has no home care, or virtually no home care program. New York happens to have a fairly generous, robust home care program. But to segue back to trusts, if somebody comes to me, and it's hopefully somebody who's vital, I would say people start thinking about this, late 60s and on. How do I protect my assets? I've worked very hard my whole life. A lot of my clients, their biggest asset is their home. Some people have 2 homes. Some people have a big, a large investment portfolio. How do I protect? The bottom line is, no matter how much you have, the law allows you to take measures to protect those assets as long as you're doing it in a legal way. And I would say my most commonly used vehicle is this trust I just described. Trust in its generic term, meaning that envelope, that box. However, now the objective is a little different. The main objective is not necessarily to avoid probate. The objective is to protect the assets so that if I need Medicaid, anything in that trust is deemed to be unavailable. So now let's think about what I said. Remember I said my trust, basically, I can put my house in and I have a provision. It's mine. I can do whatever I want with it. I can sell it. I can use the proceeds. If Medicaid sees a trust like that, I mean, just from a logical point of view, what are they going to say to Debbie Rosenfeld? They're going to say, Debbie, you have a trust. You have an envelope. It's open. Take your house out. And house is actually not the best example because in many instances, the house is protected. If you have a spouse, there are different rules, but I'm giving this as an example. Medicaid would say, take that asset out and use it as for your care. Yeah, and when you go through all the money, then we'll be happy to cover the cost of your care. So I'm not talking about that kind of trust. Unfortunately, it's a little more extreme, and I'm talking about an irrevocable trust. People have different terminology. But if you approach a lawyer and you say something along the lines of, I need a Medicaid trust, I need an asset protection trust, I need a family trust, every trust could really be the same thing, have the same objective, which is I want to protect my assets so that in case I ever need long-term care, meaning, and I want to utilize the Medicaid program in my state, I want those assets not to be counted. So the first thing, what's the first difference? That envelope that I keep talking about, this envelope is sealed, meaning I'm going to put my asset into that envelope and I no longer have the ability to take it out. Okay, and that's scary to a lot of people, right? If I put my asset in, and by the way, the trust I'm talking about, I had clients in many, many states. In other words, clients who came to me as New Yorkers, but then they retired to Nevada, to California, to New Jersey, to Florida. our trusts so far have really been recognized in many states. And obviously what I do for that client is I make a phone call to a local attorney in that area and I say, you know, can you take a look at this trust and tell me if it passes muster? What Medicaid is really looking for, the gist of it is that the assets are no longer available to Debbie Rosenfeld. Now, again, what else? I can no longer be the trustee. I have to appoint somebody else. Can the trustee be a child? Absolutely. Can the trustee be my spouse? No. So I appoint a child. Can that child also be a beneficiary? Let's say I have an only child. My child can be the trustee. That's the person who manages the trust, and they can also be the beneficiary. I love these trusts. I know it's a little harsh to say you're giving up complete control, but I want you to think about it. I never, ever tell a client, if a client comes to me and they are living on an account that, let's just say, has $100,000 in it, and they say to me, that's the money I use, that's my, that's my extra money, and I use that every time I have an additional expense, I'm not going to tell that client to put that money into the trust. I advise people to put assets into the trust that they're really not using. For example, a house is the best example because the trust still gives me the ability to live in the house. It still gives me I still pay my bills. I still pay the real estate taxes, so that very little in my life changes. What about an investment account? Many of you might be living on certain accounts, and of course you don't put that account into a trust. What if you're just living on the income? Let's just say you have a $500,000 account and it's generating $20,000 of annual income. You don't really touch the principal, meaning the principal is sitting there, but it gives out, you take the income. That's a perfect asset to contemplate putting into a trust, because the beauty of the trust is that our clients can continue taking the income. So again, principal unavailable to Debbie Rosenfeld. But income, meaning dividends, interest, or even rental income from an investment property, that continues to be paid to me, so that therefore I am continuing my life as I did before. I've given up a little control, but very little in my life is changing, and because I'm getting this income. And then again, remember, so that anything that's in that trust is protected if you need Medicaid. And furthermore, let's just say you never need Medicaid. God willing, I hope none of my clients ever utilize these trusts, but they also serve as testamentary assets, meaning that whatever is held in that trust will ultimately pass to the named beneficiaries in that trust, meaning just like a will, that you avoid probate. So I know I started this by saying I could talk for hours. I really could. I want to say one final thing. This is relevant to people who live in New York, but also, again, to anybody in the United States vis-a-vis Medicaid planning. New York, I guess this happened right in the midst of COVID. Every single state now is experiencing major budgetary crises, right? You know, the economy is terrible. People have been out of jobs, and Medicaid is going to be one of those programs that they're going to try to squeeze. They're just going to try to change some of the provisions. So I mentioned that there is nursing home care has a 5-year look-back period. In New York, it used to be that there was no look-back period for home care. That is changing, and as of October 1st, there will be a 30-month look-back period for anybody who needs Medicaid. I'm throwing that out there because anybody who's considering doing a plan like this probably should consider doing it before October. That's if you live in New York, and if you live elsewhere, you should try to be apprised of the rules, because I'm sure there have been changes. So again, I welcome emails, questions. If you have any specific questions or you want to meet for a greater period of time, I'm happy to do so. And thank you so much for your time today.
Wow. Debbie, thank you so much. I think we all learned a tremendous amount. I'm sure everybody is going to be thinking very soon, if not today, about addressing all these issues, with the idea that, Chas v'shalom, we hope never ever to have to implement anything, but we should always be prepared. We thank you very, very much. Later today, the recording of this program will be sent to everyone who registered. So if you came in late For those who you know weren't able to access it because maybe they're working or of something else, everybody who has registered for the program gets a recording. We will include Debbie's contact info. And I think, Debbie, you said you're going to be sending me some other materials.
Yes, I will.
So please look for that. Okay, and on Thursday, we will be continuing our legal scenarios with halachic issues of end-of-life matters, and it's called A Conversation for Mortals with Rabbi Elchanan Zone, who is the director of NASC, that is the National Association of Chevra Kadisha. He is known throughout the world for his work in this area, and he will be discussing many of the issues that Debbie already alluded to and others. Okay, so another couple of housekeeping matters. If you received an email from SurveyMonkey, not everyone did, but if you did, it is not spam. It is not junk mail. Please, if you haven't filled it out yet, please fill it out. The information from it is very, very important to the continuation of the program. This is important for all nonprofits that we know who's attending our programs. If you haven't been to various programs that are outlined, don't worry about it. It just says that you didn't attend. But the fact that you complete it and give us some of your ideas and even tell us where you're coming from. We know that there are people, it's very, very exciting. I know Debbie made a comment about it. There are people throughout the United States that listen to the Spirit, that listen and watch the Spirit program. Beyond the United States, we have quite a number now in various areas of Canada, in various areas of Israel. And I know that we have somebody, at least one person from Australia. Baruch Hashem, this has become an international program. But we want to know exactly where people are from, how you've heard about it, what we can do to promote it more, and what other programs you're interested in. So whether or not you have attended various programs, even if this is the first one, if you do get that email, please complete it. We really appreciate it. As I said, all of the programs are recorded. So when you will get an email from me, hopefully later today or tomorrow, don't delete it. That's your recording. And there's a link on it that will lead you to the recording. So you don't have to ask me for it. It's going to come to you naturally. I also want to thank our partnering synagogues throughout the United States who are helping us to spread the word about this program. If you see an email and your shul is not listed, please speak to your rabbi or president. It's very easy. All they have to do is contact me. We will put them on as a contact. We just ask them to spread the word. There is no cost to be a partner synagogue. It just helps us get more people on this program. I think that's about it for now. I want to wish everybody have a great day. Be safe and healthy. We'll see you on Thursday. Thank you so much for joining us. And Debbie, thank you again.